Okay, let us look at mutual agreement procedures, and particularly let us look at the different sources of law that there are, because it is getting a little confusing, so it's good to have perspective. First of all, because mutual agreement procedures and arbitration are discussed together in the treaties, I'm putting them together here. The idea being that you have a mutual agreement procedure trying to come to an agreement. If you can't come to an agreement, the mutual agreement procedure says then you have to go to arbitration. And of course, the idea is not that every map ends up in arbitration. The idea is that countries wouldn't like going to arbitration, and therefore they would solve the maps before they go to arbitration. I've got three main institutions involved with this: the OECD, the UN, and we're also going to look at the EU, because they are actually historically the front runners, in the sense that the OECD made the arbitration convention already in 1995 in order to solve transfer pricing double taxation cases within the EU. Under the OECD, we've got four sets of rules. The first is the Model Convention, Article 25, and the commentary to Article 25, which concerns the mutual agreement procedure and arbitration. But then don't forget that Article 7.3 for permanent establishments and Article 9.2 for intercompany transactions also require corresponding adjustments from the other state, and in their commentaries talk about to what extent 7.3 and 9.2 are alternatives for Article 25, or actually are preceding Article 25. And then we've got the transfer pricing guidelines, which has a chapter about mutual agreement procedures and an annex about advanced pricing agreements, but we only stick to mutual agreement procedures for now. And then we've got, as part of BEPS Action 415, we've got something called a multilateral instrument. And the multilateral instrument covers various treaty changes from the 15 BEPS action points, among which being Action 14, dispute resolution. And Articles 16 to 26 deal with a standard mutual agreement procedure clause, which then also includes arbitration clauses, and those arbitration clauses can either be voluntary or, what the OECD prefers, mandatory. And when you are in arbitration, and we'll get to this a little later, you can also choose between normal arbitration, where the arbitrators choose one of the two party solution all their own, or you get something called baseball arbitration, where the arbitrators only can choose one country solution. So either choose country A solution or country B solution. And the interesting thing about baseball arbitration is the most likely scenario is that the arbitrators will choose the solution which seems the most reasonable. So where you don't have baseball arbitration, countries can sit as far as possible away from each other, hoping that they'll meet somewhere in the middle. But when you've got baseball arbitration, both countries try to be as close to the middle as possible, because then they hope that the arbitrators will choose their solution. So it actually mitigates a lot of the discussion up front. The UN follows the same model. It's got Article 25 plus the commentaries. It has Article 9 plus the commentary. Remember, it does not have an Article 7.3 because the UN rejected the AOA. And then it's got the practical manual, which deals with arbitration and mutual agreement procedures in Chapter 444. And then we have the EU. And the EU has, first of all, the Arbitration Convention, which I believe is a 12-page document dealing with mandatory arbitration, basically. If there's no resolution after, I believe, 2 years, the taxpayer in a mutual agreement procedure, the taxpayer can ask for arbitration, and the arbitration must basically be done within 2.5 to 3 years. And later, as a consequence of BEPS and Action 14, the EU has also implemented a dispute resolution directive, which deals with how to solve tax disputes within the EU. And that directive deals briefly with with mutual agreement procedures, and then more extensively also with arbitration and alternative dispute resolution forms. So let us look at what a map request look like. And just to be clear, unless you have a PE, I mean, if you have two taxpayers, either taxpayer can file this TP adjustment map request, right? Because we're talking about TP, which means that there will always be two states involved with two different taxpayers. For instance, if you have a dispute about residence, you typically have one state where the taxpayer is resident where you can file the map request, but in transfer pricing you've got a taxpayer in each state. That's why you've got a transfer pricing issue. And then you can file the request in either state. Some states may be very formalistic and say you can only file it in the state where the adjustment has been made. But I don't think there's any legal grounding in that unless they have it in national law. So you can file it in either state, or you can file it in both at the same time. As a general rule for taxpayers, unless you really want to upset one of the tax authorities, it is good practice to make sure that whatever is sent to one tax authority is also at the same time sent to the other tax authority, to show that the taxpayer is not trying to advantage the one tax authority over the other. And no one's saying that you can't start by doing that with the mutual agreement procedure request. So a mutual agreement procedure request typically would have the taxpayer's name, the address, and the taxpayer's identification number. And in the EU, this is not included in the text here, but in the EU, you typically, not typically, but there are countries which expect you to indicate in the request whether you want the mutual agreement procedure to be done under the treaty, for instance, between Holland and France, or Germany and France, or whether you want to have it under the arbitration convention. Quite frankly, I don't think taxpayers should have to indicate that in the request. The fact is that the arbitration convention applies to all MAP requests, and I think it's a little restrictive of countries to try and say that if you didn't say in your original request whether this is an EU arbitration mutual agreement procedure request, then you can't have arbitration. Hopefully there are not too many jurisdictions which do this. Anyway, we have the taxpayer name, address, and taxpayer identification number. Logically, we would have the counterparty name, address, and taxpayer identification number. And then you would have the name of the other foreign tax administration involved and the name of the tax office making the adjustment. So it could be the German tax administration which is involved, and it will be the Curlin tax office which has made the adjustment. We talk about the tax treaty articles that are not being correctly applied and the taxpayer's interpretation of the article. In the case of transfer pricing, this should be Article 9 or Article 7. We talk about the tax years involved, obviously. And then the relationship, the situation, the structure of the transactions, issues, and the related parties involved. So because you can have that there's an adjustment between two companies, but it may affect several other companies, right? Think, for instance, of our example where we have a US multinational using one Scandinavian state to distribute its products into Scandinavia through that one state and PEs. Now, if one of those PE states make an adjustment, it could very well be that the adjustment should not be targeted at the head office PE profit allocation, but at the fact that the US has sold the products for the wrong price to the head office state. So that's something you could indicate here. Then you want a summary of the facts and analysis of the mutual agreement procedure issues, including issues raised particularly by one of the tax administrations and the amounts involved. Also, tax administrations, especially when they have limited resources, need to prioritize the maps, and unless it's a matter of principle, they would typically do it by the amounts involved. The relevant TP documentation of the taxpayers, a copy of other relevant competent authority requests, associated documents, and the correspondence. It might be that you are asking a competent authority to intervene in an adjustment made by the other country, where that other country has made the same adjustment for other group companies in your M&E on the same grounds. An indication if the taxpayer made a prior map request to a contracting state on the same or related issue. A schedule of the time limitations in each jurisdiction for the years for which relief is sought. And here the rule is typically countries are discouraged from arguing that you can't have a map because the statute of limitation has expired. On the other hand, taxpayers also have the duty to try and file the map request as soon as they're convinced that there is going to be an assessment, in order to preserve the statute of limitations, right? And then a statement indicating if the taxpayer filed a notice of objection or a similar document in either jurisdiction. Obviously that is related to the case, so tax authorities need to know that. A statement indicating if the request involves issues considered by either tax authority as part of an APA. Again, you could have a 3-state issue where an APA request is running between state A and state B, and state A has made an assessment for the very same issue with regard to state C. And it would be nice for state C to know that this request was this APA discussion with state B is ongoing as well. And just back to point 12, for instance, it will be very important for some tax authorities to know whether the taxpayer has filed an appeal with a court on this assessment, because some tax authorities say we cannot rule against our own courts, as we discussed before. Assign consent for a person to act as an authorized representative in making the request. This is if you have a consultant doing the request for you. Quite frankly, I think taxpayers should try and do that themselves, especially when they have in-house tax departments. Other facts that the taxpayer may consider relevant. A copy of any settlement with the other jurisdiction which may affect the mutual agreement procedure. And that is it. You are ready to file a full mutual agreement procedure request. Let us look at a typical timeline for a MAP procedure. Now, this is something I've done a couple of times because I spent 3 years with the Danish Competent Authority for Transfer Pricing, and in that time dealt with a number of MAP procedures. So I'll try and talk you through this as we go. Our timeline comes from MEMAP. It was a document the OECD issued about best practices in the mutual agreement procedures. It largely follows also, I should say the other way around. The EU has also, during the arbitration convention, published a code of conduct which tells tax authorities how long MAP procedures should last, and then both the MEMAP and the EU timelines follow each other pretty closely. But we'll look at MEMAP only. The whole process is divided into 3 stages here. First is submission of the MAP request. The second stage is when the authorities, the common authorities, negotiate, and the third is then their solution and the acceptance or rejection by the taxpayer. So in the very first case, the initiation of the MAP by the taxpayer, a submission of the MAP request, which should have the information and follow the guidelines that we just looked at in the previous slide. And the taxpayer must do this within 3 years from notification of the action giving rise to taxation not in accordance with the convention. And this is a trick, right? First of all, on the MEMAP, tax authorities are not supposed to try and trick taxpayers out of MAP. But you could, for instance, have that a tax inspector indicate that he's going to make an adjustment in year 1. And you negotiate with him maybe for a year, and then he finally makes the assessment. Now, if you read this text, then theoretically, after the assessment, you've only got 2 years left to file your MAP request, because you knew that there was a reasonable chance of tax being levied according to his opening statement. And you need to be aware of this kind of situation. Typically, tax authorities should not use it against you, but that is the theory, and of course the practice can be different. Now, after you've submitted your request, the tax authorities confirm that they've received your request, and they submit it to and then they let the other competent authority know. In transfer pricing cases, the taxpayer or associate enterprise in the other country is also encouraged to contact the competent authority of the other country and to promptly and simultaneously provide all supporting materials. And if you do this, you need to send exactly the same package to both competent authorities. Preliminary review of the case by the competent authority that received the request, and possible requests for additional information to the taxpayer. And for this, typically the competent authority has 1 month. So you get a letter saying that that you think that there is a MAP case. You provide all the supporting documentation that we listed before. The competent authority reads through it and say, this is great, I actually have these and these and these other factual questions, or can you please submit this, or can you please submit that, etc., etc. And then they have a month to do that. In the next step, the competent authority decides, is this case eligible for MAP or not? Yeah, and they give the taxpayer notification. If it is accepted for MAP, then the MAP procedures can start. Now, there's the option here which is not listed here, and that is that the competent authority can review the case and can think, you know what, actually I agree with the other guys. Or, more practical, you know what, the amount involved is so small, we are so busy, we don't have time for a MAP procedure about this. I can't refuse the taxpayer, I'll simply make the corresponding adjustment. Yeah, those are two options that exist at this stage. And then finally, a confirmation by the other competent authority of receipt of the MAP request, preliminary screening of completeness and of the request, and notification of decision to accept or reject. Because remember, it is not so that the acceptance of one competent authority can bind the other. Both must agree that they want to go into MAP. The other competent authority can say, you know what, I'm sorry, but there's been a court case in our country already. We cannot override the courts. Or the other competent authority can say, you know what, in our country, this particular adjustment was accompanied by a serious penalty, and we do not do MAPs on criminal cases. Now, in some countries, such as Italy, a serious penalty is incurred very, very quickly, especially in transfer pricing cases, because it might simply be double the tax due or something like that, right? But in any case, the other competent authorities should also agree to accept the case. And then you get to stage 2. And in stage 2, there is an evaluation by the competent authority of the country that initiated the adjustment, the initiation of MAP consultations with the other competent authority, and issuance of a position paper. And the position paper is basically a defense paper saying, we believe our adjustment is justified because of this and this and this and this and this reason, right? And this should happen ideally within 4 to 6 months after agreement between the competent authorities to enter into MAP agreements. Then the other competent authority review the case. It does a screening of the completeness of the position paper, because they may actually have questions about the position paper, and notification of missing information and determination whether it can provide unilateral relief to the taxpayer. So here the other competent authority gets the chance to say, okay, I'm going to just unilaterally relieve the case. Remember, in the first instance, if we look at the block on the left-hand side, this is written on the assumption that the request is submitted to the adjusting authority, which is why they've left out there the possibility to simply make a corresponding adjustment. But you can make your MAP request to the other authority, and they can inform the adjusting authority, listen, we have received a MAP request. Yeah, or you can submit it to both of them at the same time. But if you've done it to the adjusting authority and they've put the position paper to the other authority, then the other authority, if they haven't done so yet, can make a corresponding adjustment, because quite frankly the other authority could also have made the corresponding adjustment in step 4 of the first stage. But either way, they've got 6 months to look through the position paper, decide what their position is, and then they've got to negotiate. And in practice, this is very often the biggest bottleneck, for a couple of practical reasons. The first one is negotiations still tend to go on face-by-face basis, which means that someone must have the time to travel to the other country, and the other country must have time to meet with them. Now, in theory, this should not be a problem, because if one assumes that map cases are divided more or less equally among the countries, but that's not the case. If you look at countries like Singapore, if you look at countries like Switzerland and Ireland, they tend to have a disproportionate amount of map procedures, because countries like Denmark or maybe Germany or France or Italy do quicker, and I'm going on a limb here, but that's my experience, quicker would make an adjustment if the counter country is in a low tax jurisdiction than if it were in a similar high tax jurisdiction. So that you get that maybe Denmark has cases against the US and against Sweden, and then a lot of cases against Switzerland. And if you look at Switzerland, which is more or less equal in size in terms of inhabitants compared to Denmark, they don't only have map cases with 3 countries, they have map cases with 30 countries. Because 30 countries have made adjustments to what they deem to be a low tax jurisdiction, and where they fear to be base erosion and profit shifting towards that low tax jurisdiction. So the face-to-face meetings can slow things down between competent authorities. But in theory, they should come to a conclusion after 6 months, and then the mutual agreement between the competent authorities document can take the form of a memorandum of understanding, where they say, okay, we agree with this part of the adjustment, and this is how we're going to fix it. And if ever you are in a mutual agreement procedure and you see these documents, be sure of one thing, and that is, don't only look at text. Insist that the competent authorities make actual calculations of the adjustment, and that they agree on the calculated amounts. Because if you don't, you run into trouble. For instance, competent authorities may think that they've agreed everything about the numbers and come to a conclusion, and then when they try to calculate the numbers, they may have realized that they never discussed the timing of currency exchange differences. For instance, is the adjustment going to be made at the currency of the time of the adjustment? Is the adjustment going to be made at the currency at the time of when the tax was due, or is the currency going to be calculated at the time when the competent authorities have come to an agreement? Those kind of things, especially with large adjustments, can swing the outcome of the map procedure in millions, the one way or the other. So always insist on having a calculation of what the agreement is, a number, not just a principle. The taxpayer approves the mutual agreement, or they reject it, right? And this is an important thing to remember. I mean, the competent authorities could have negotiated for 2 or 3 years, and then they put their outcome or their conclusion to the taxpayer, and the taxpayer has the right to reject that mutual agreement, which then means that the taxpayer would have to pursue the case further in court, if it can still go to court. And the taxpayer would have a serious relationship problem with at least one of the 2 competent authorities going forward, because they've just spent a lot of time trying to reach an agreement which was then rejected. And then if they accept it, then there's confirmation of the mutual agreement with terms and conditions, and an exchange of closing letters where you summarize everything, and there is the implementation of the mutual agreement. So if you don't if you manage to come to an agreement, this is what a mutual agreement procedure would look like. If you don't manage to do it, then somewhere around here or somewhere at the end of stage 2, the taxpayer would simply say, guys, I would like you to go to arbitration. Or as we see in the UN model hereafter, it's not for the taxpayer to decide that, but one of the competent authorities can say, you know what, we don't come to an agreement, let's go to arbitration.